Good evening. I'm afraid it's going to have to be in English, but I'm sure that you have been forewarned. I have been told that I speak clearly, and so it should make it easier, and I will speak slowly. So have a nice evening. Ladies and gentlemen of the jury, I stand before you as a representative of Pets András, the plaintiff herein. I'm sorry, I misspoke. Actually, I didn't describe our relationship to the fullest extent of what it is. I'm not just his representative, I'm his voice. He would be talking to you this way, but for the fact that I am here to speak for him. Now, you have been sitting here for the last 2 weeks, paying close attention to the evidence. Every day, I see your faces focused, taking notes. And I must tell you, I congratulate you because your job is not an easy one. You've heard the evidence, and I'm not going to regurgitate the evidence for you, but I am going to just roughly run over the salient facts. As you have heard, András here was driving his automobile at the legal speed limit, paying attention to the vehicles and the traffic around him. When the defendant sitting over there, Mr. Jones, inebriated, drunk, we should say, ran a red light and hit him in the full force of 50 kilometers an hour, no brakes on the left-hand side of his car. As a result, András' small car was crushed. Not only the car, but his left leg. It was crushed. When the debris was clear and the smoke cleared, he was blocked into his car. He couldn't get out. The fire department and the ambulance came. They had to cut him out of the car, cut the metal parts out to be able to bring him out. The ambulance rushed him to the hospital, and very sadly, his left leg had to be amputated. Now, you're sitting here, I observed you walking in. All of you have 2 legs. You do not know what it's like from one day to the next, suddenly just have 1 leg. You need a prop, a crutch, or a prosthesis, and even then, your life will never be the same. And this is what Mr. Jones did to my client András. Afterwards, the police took him down to the station, and his blood alcohol level was found to be 0.15. Do you realize, ladies and gentlemen, how high that is? It totally took away his judgment. He was unable to see the light that was red for him and green for András. He drove right into the car because his mind was clouded with alcohol. Now, you know all this because you've heard the evidence. You saw András' family in court. His 3 sons, the twins, and his older son. You saw his wife sitting there. You know the entire story. You heard from him. He explained what his life was like before this shattering, horrible day. He told you how he likes to play football with his children. He told you how he's a very good skier, that he was waiting for his sons to get old enough to be able to go skiing with him. As they got older, the twin boys are 3. They got into 5, 6, 7 years old. Could go out on a green lawn and kick the soccer ball around. Is he going to be able to do that now? I'm afraid not. So we are here, and I try to understand from his soul how he feels. And I'm going to try to convey this to you so you will understand how he feels. And we are here to ask you for justice. Now, how can someone be given justice who lost a left leg or any leg? Ladies and gentlemen, I'm sorry to tell you, as materialistic and crass as this may sound, the only way this justice system of the courts can do this is by awarding monetary damages. Now, I know how terrible it sounds to you who have never experienced this, to say or have someone say to you that a leg is worth X number of dollars, an arm is worth so much, an eye, if you lose an eye, is worth Y number of dollars. The best thing would be for everyone, you, me, and mostly for Andras, if I could ask you to wave your magic wand and say, Andras, you have your leg back. Just the way it was before Mr. Jones did their terrible deed. But we can't do that. That's not within our power. That's not within any human power. So what can we do? We can award them monetary damages. How much do you say? Well, I will come out to you straight and say $3 million. $3 million. Now I look at your faces and I see some doubting looks and saying, wait a minute, how can you say a loss of a leg worth X amount of money? Well, as I said, you can't give him back the leg. So you have got to consider, how did I reach this number? How did I come up before you and say, $3 million, why not 2? Why not 4? Why not 500,000? Well, let me ask you this question. Would you give up your leg for $10 an hour? Lucifer or anybody come up to you and say, you need money? I'll give you $10 an hour for the rest of your life. Give me your leg. Would you consider that an outrageous proposition? I would. Andras would if he was given a chance. But was it? Was he given a chance? No. Mr. Jones didn't consider that when he was putting away all those drinks. He was thinking of himself and his fun. Now we're here to say, Mr. Jones, you must pay for what you've done to this good man, who is going to have this problem the rest of his life. Even if he gets a prosthesis, it's not going to be the same as a leg. He's not going to be able to ski like on 2 good legs. He's not going to be able to kick the soccer ball around with his 3 boys. We're going to say, Dad, come on, play with me. Can you imagine the heartache that's going to hit him every time his son or sons are going to say, Andras, come out and play some soccer. And he's going to say, I'm sorry, son, I can't. Why not, Dad? Well, I don't have 2 legs like you do. I can't run around like you do. So, let's just, for the sake of argument, say, $10 for your leg? Are you outraged? Would you take that bargain Would any of you take that bargain? I submit to you, ladies and gentlemen, that you would not. You would say, $10, $20, $100, I wouldn't give you my leg. Now, if we just take the $10 an hour, and I took my calculator, and if you wish to check my numbers, you go ahead. $10 an hour over a period of a year is approximately $90,000, $100,000. He's 40 years old. According to the actuarial tables, he is expected to live at least until the age of 72. That's 32 years. Now, you multiply the 32 by the 90, and you come out very close to $3 million. So, if you say, well, that's a pretty outrageous sum, I say to you, yes, it is. But what he did was an even more outrageous thing. He didn't think about his fellow man. He could have killed a child. He could have hit a pregnant woman. And to Andras's bad luck, it was him that had to suffer. So I ask you to consider all the evidence. And there is no doubt when you look at the facts, and you will be the judge of the facts, if you find that Mr. Jones drove his vehicle inebriated, which in itself is a violation of the law, ran a red light, which is an outrageous violation of the law, because that's why we have a system of green lights and red lights. And he struck this man's car and affected his life in a way that none of us know. He doesn't know. It's going to take 32 years, or perhaps even more, if he's lucky and lives to be 80 years old, to find out every blessed day the things he can't do, or can't do as well as he was able to do before. So, ladies and gentlemen, you are the judges here. You are the deciders. His fate is in your hands. You are going to walk out of here feeling like, I've helped this man as much as I could. You're going to walk out of here saying, justice was in my hands for just a little while. How often can we say that about life? Always somebody else is doing things to us. Today, you have a special day before you. You can bring justice. And I ask that you bring justice to Andras, my friend. Thank you very much for your attention. Well, boys and girls, what you just heard was a jury argument given in any of the tens of hundreds of thousands of courts in the United States. The way the system works in America is that every litigant has a right to a jury trial in a criminal case or in a civil case. This was a civil case based on tort, a tort of negligence. And we're going to talk about the different areas that entitle a litigant to damages. This was one of the most common cases in the American judicial system, because the way it works is that negligence is probably cause of 80 to 90% of the lawsuits that are heard in a court of law in America. Contracts and other cases are much less frequently go to court. Now, let me talk a little bit about some general things about damages which affect a litigant and, of course, the course of the litigation itself. The first and most important thing is that the United States has 51 jurisdictions, 50 states, and the federal government. Now, if you have a lawsuit, the law gives you a choice of where you're going to file this lawsuit. One place that's always available is the residence of the defendant. Another place that's always available is the location of the wrong. Wherever the thing that gave rise to the lawsuit happened. And there are some other areas, but these two are the most important. Now, let's say, for the sake of argument, that Mr. Jones was a resident of the state of Kansas, but he was traveling in California, and he got drunk in California, and he was driving his car in California. And the accident happened in California. Now, let's just say that Andras was a resident of the state of Louisiana, and he was visiting California at the time that this terrible accident happened. So Andras goes to a lawyer because he's still on vacation, and the lawyer probably has to go to the hospital. And his wife, Judith, calls a lawyer goes to visit him in hospital, takes down the facts. And of course, Andras, not the same Andras is sitting here, because he is extremely well versed in the law. Not just Hungary, but all of the states of the United States. So he knows things. But the Andras that's sitting in the hospital doesn't know so many things. So he's relying on this lawyer. And so the lawyer says, okay, I've looked at the police report. I have seen where the defendant is from. Now, we can sue him in Kansas, and that's a little closer to your home in Louisiana than California, because sooner or later you're going to have to go back home. But, says the lawyer, in Kansas, the juries are very conservative. In California, it's a free society. The juries love to give away somebody else's money. If we sue in Kansas, the most we're likely to get is maybe $500,000 to $1 million. But in California, easily 2 to 3. Now, of course, I'm going to go and ask the jury for 3, and they'll probably say, well, he exaggerated a little bit. We'll give him $2.5 million. Now, I think under the circumstances, I'd certainly be happy with it. He probably would rather have his leg back, but he said, I can't have my leg back. At least $2.5 million could make my life a little sweeter than if I had nothing. So the lawyer says, we should file a lawsuit in California. Okay, we file a lawsuit in California. This is just one example. Now, at that point, Andras, being unknowledgeable in these matters of legal things, says, well, do we ask for a jury, or do we just ask for a judge trial, a court trial? And the lawyer says, oh, no, Andras, we want a jury, because the judge has seen too many of these cases, and they are just not as free with the money, because they are not going to be touched by things like he can't play soccer with his children. Now, if the judge has only girls, maybe, or no children at all. Well, playing soccer is no big deal. What's the big deal? But you, ladies and gentlemen of the jury, you're back in that role. Some of you have children. You know what it's like to be able to play with your children, spend time with your children, go hiking. A jury will understand that. The judge is going to say, go on, counsel, it's about lunchtime. Well, in a case like this, you don't want a judge trial. So you go to a jury trial in a state that is likely to give you more that's within the law as to what is jurisdictional availability. This is called forum shopping. So you have found a forum that you want to use. Now, the layout of a case is that if it's a jury trial, the judge does certain things and the jury does certain things. Now, the jury is the decider of the facts. The judge is the decider of the law. If the issue is, was there negligence? The jury is asked to find not whether there was negligence. The jury is asked to find, was the defendant drunk? Did the defendant run the red light? Facts. When you put them all together, the judge at the end of the case says, ladies and gentlemen, if you have found that the defendant had consumed alcoholic beverages to the extent that his blood alcohol level was 0.15, and you found that the traffic light was red when the defendant proceeded through it, you have to find that he was negligent. Now, the jury doesn't have to think about that. The judge will tell him, you just tell me what the facts were, and I'll tell you what to do with them. Now when it comes to damages, that's purely the jury's province. The judge is going to say, ladies and gentlemen, you find the right amount that the plaintiff is entitled as far as damages are concerned. And so I, as the attorney for the plaintiff, urge you to give him $3 million. Now, Jones's attorney is going to say, well, we are so terribly sorry about this terrible thing about the leg, and certainly we admit that Mr. Jones was negligent, but $3 million, that's outrageous. That shocks the conscience. $500,000, okay? Now, you retire into the jury room and you select 12 of your fellow jurors and the foreman, and then you toss the numbers around and you come up with a number and you come out into the court, or you send the bailiff or knock on the door and say, Your Honor, we have a verdict. And you have a piece of paper, you fill in the amount. And the foreman signs the piece of paper. It's a little piece of paper, just about like that. Foreman signs the amount, the bailiff hands it to the judge, and the judge says, hands it to the clerk and says, Miss Clerk, read the verdict. It says, we, the jury, find for the plaintiff in the amount of $2,500,000. End of the case, right? No. No, it's not the end of the case. Why? Because the law says that even though you as jurors are the arbiters of damages, the judges have to have some power of supervision. You say, well, wait a minute. If we're the judges the damages. What's this power of supervision? Well, it says that maybe you got swayed by my silver-tongued statement to you about all the money that Andras is entitled. And the picture of him not being able to play soccer with his boys. And you just got carried away. 3 million, 2.5 million. You are, that's too much money. Well, who says? Well, unfortunately, the law says that the judge can meddle. Now, in America, we have what is known as the common law with precedent. But since there's no two case that's exactly alike, we can always say, well, yeah, I mean, that's very close, but we'll just have to kind of go along and say, in this case, that there's no precedent. So the judge says, well, I think that the 2.5 million is unconscionable. It shocks the conscience. Well, where do you turn? Nowhere. You're stuck. You're stuck. What happens is that Jones's lawyer says, at the end of the case, you have all gone home to have dinner, and you're feeling satisfied that you have done justice. And the following morning, Mr. Jones's lawyer comes into court with a motion for a new trial, or in the alternate, remititure, which is a wonderful Latin word which says reduction. And so he says, this was an unconscionable amount of money. Your Honor, grant us a new trial. What does it mean? It means everything starts over. Everything starts over. You got to have a new jury. You got to have all your witnesses out of state. You know, you make a new presentation to a new jury, and then maybe something will happen. Well, I tell you, I had a case where I represented a lady who was raped in a resort. And the resort was negligent. I'm not going to go into the facts of the case. The resort was negligent in keeping the rooms safe. And I got a jury verdict of $583,000, which at the time, this was in 1984, I think, was the highest jury verdict in a civil case on a rape case when a person was raped and sued somebody for anything, you know. Usually you don't sue the rapist because the rapist has no money. You get a judgment, and it's going to laugh all the way because you'll never collect. So you got to find a deep pocket defendant. The owner of the resort is a deep pocket defendant. So the owner, the attorney for the resort made the motion for a new trial. A large percentage of time, 80% perhaps, judges say, hey, the jury spoke, that's it. The smart judges, the good judges, number one, they don't have to work. They don't have to write an opinion, and they get the motion, look at it, motion denied, the jury spoke, thank you very much, next case. In my case, lucky as I am, I had a judge that was a civil service employee all his life before he was appointed a judge, and he made very little money. And he looked at his papers and said, $583, I've never seen that much money in my life. Oh, that's got to be too much money. So he wrote a 20-page decision and said, well, yes, there were some errors made, and the defendant is entitled to a new trial, but I'm going to cut the verdict from $583,000 to $383,000. And if the plaintiff accepts the reduction, then the motion for a new trial is denied and everybody can go home. Now comes the job of the lawyer. You go to your client who's sitting there 24 hours a day saying, I got $583,000. Ooh, boy, what am I going to do with all this money? And you knock on the door and say, Maria, the judge just did something. What did he do? He cut it $200,000. Oh, that's terrible. And then you have a sales job. Big time. Because you have to sit there and say, well, you flew over here from Belgium, and it's true. You're not going to go back with a single penny in your pocket if we're going to have a new trial, because we have to get scheduled back in. It's going to take 6 months before a new trial date can be obtained. Then you have to come over here. We got to get all the witnesses. And who knows, maybe the next jury won't be as sympathetic. Maybe you're going to get less than $383,000. So what are you saying? You're saying I should take the 383? Yes, you should. I got to think about it. I said, you do that. I'll be back tomorrow morning, and I want your answer. And I'm also going to tell you that if you say no, you got to get another lawyer. Because I'm not trying to say this case again. Oh, well, I liked the way you did the work. I said, I do too. I did a good job. But I ain't going to do it twice, just once. Thank God, Maria Teresa accepted the reduction. And I took her and her fiancé out to dinner in a very expensive restaurant in San Francisco. And I said, you made a good decision. A very good decision. And this is another job of a good lawyer, which goes way beyond law school. Is to sit there and to say, you have the rest of your life before you. You don't want to sit in a witness chair under cross-examination answering questions about what it was like for this black man to enter your room with a knife and sit on you holding the knife, and then the attorney asking you now, how long did he sit on you before he ripped your clothes off? So you want to go through that again? 2 days of it? No. It's over. Go and start your life today. You got some money in your pocket, and live it and look forward and don't look back. Put the curtain down and it's over. And that's a job of a psychiatrist or a psychologist. But a lawyer has to be an accountant, a psychiatrist, a nursemaid, etc., and then be able to give a closing argument, as it's called, just like I did to you. So you're all lawyers here, so lawyering is a tough job. Now, one other element of this, which is very important in the subject of damages, is the fact of a contingency fee. Now, Andras traveling from Louisiana to California, having a vacation with his lovely family, suddenly is in the hospital, and God, what are you going to do? We can't go back. I mean, there's a lot of problems. Going to be in the hospital for a few weeks, and a lawyer comes to him in the hospital room. Now you say, well, lawyers cost money, don't they? I certainly hope so. I mean, I became a lawyer. I said, I'm not going to do this for free. So, yeah, lawyers cost money. And good lawyers cost a lot of money. So Andras is sitting there and said, well, I took $2,000 for this vacation, and I don't have any money. I mean, you got to get home. I don't have any money for a lawyer. Ah, that's when the contingency fee comes in handy. The lawyer says, well, tell me the facts. And well, you know, the guy was drunk. 5 stars. He ran a red light. 5 more stars. Good case. I think I'll take the case. But I don't have any money, is it? Andras, don't worry about it. I'll take the case on a contingency that if we recover, I get 33%, says the lawyer. You get 66. You don't have to spend a dime. All the expenses are mine. And if we win, I get the expenses back, plus my 33%. And you don't have to worry about a thing, except at the end, I'll hand you a check, which will be a nice check. He says, that ain't bad. I can handle that. And then he says, well, what happens if we lose? And the lawyer says, I don't get paid. You don't owe me anything. He says, oh, I'm beginning to like this even better. So no matter what happens, I don't have to pay you. No, sir. No, you don't pay me. The other side will bring some money, and I take some of it, and then the rest of it is yours. You say, wow, that's all right. That's all right. Now, remember this. I don't think they have that in Hungary. But if they do, my apologies. It makes a great deal of sense from a point of view of justice. If you are an indigent person, or you're not an indigent person, but you don't have enough money with your kids going to school and your wife pregnant, you don't have enough money for a lawyer. You got every dime. You got to pay rent. You got to pay the car payments and the food on the table and so forth. Yeah, you can't just say $5,000-$10,000 to a lawyer. And if somebody says, well, yeah, but you get that back in 2 years, 3 years? Where am I going to get it now? You know? And you say, well, I guess I'm not going to have a lawsuit. But in the contingency situation, you are going to have a lawsuit. And most of the time, and if you went to a good lawyer, he will say, not in a case that I described or I argued to you, but in other cases, you will say, Andras, you don't have a case. Give you an example. You're walking down the aisle in Spar, and you slip on something. You don't know what. And you fall, and your hip bone breaks. And you're laid up in the hospital. You may have to have a hip replacement. You know, big numbers, doctors, hospitals, no work for I don't know how many weeks, whatever. And you go to a lawyer, and you tell him all this, and you say, what did you slip on? Was that a banana peel, a piece of fruit, or something slippery on the ground? I don't remember. Or say, well, there was some water or some liquid on the pavement, on the floor of the store. That's not enough to prove negligence. In order to prove that the store was negligent in not wiping off this wet spot upon which you fell, you have to prove that it was so, it was there for so many hours or so long a time that a store employee walking by wouldn't notice it. Supposing one of the coolers was leaking, and in the last 5-10 minutes, the liquid was on it, and that's what you slipped on. Well, that's not negligence. Negligence is if the store knows there is some dangerousness, and they don't do anything about it. And it's your proof. You got to prove it. And if you can't prove it, you don't have a case. Somebody comes to me like that, I'll sit down and I'll listen to him very gently and carefully, and then I'll say, you know, ma'am or sir, I can imagine the pain and the discomfort, and you with the new hip and all that, and the thousands of dollars you have to spend on medical expenses, which in America are not covered by the state, by the way. Maybe not even your insurance company. But you don't have a case. And a good lawyer has a responsibility not just to see the stars of the hundreds of thousands of a jury verdict, but to say, in my experience and my knowledge, I tell you, you don't have a case. To which the client says, well, there's other lawyers. I'm going to go to another lawyer. And it's going to go down, 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 where finally he's going to find somebody so hungry and so incompetent and so inexperienced, they say, okay, I'll take your case. Well, they are both going to go bankrupt because that's an unwinnable case. Now, the old saying is that there are unlosable cases and unwinnable cases. An unlosable case is a case that even an idiot who has never been to law school couldn't lose, because the facts in the law are stacked so beautifully that you can and you win, okay? And there are cases which are unwinnable, which means 99 out of 100 times you lose. Now, people used to come to me and say, well, what are my chances? And I'd say, well, what would you like me to tell you? Because if I tell you that 100% we're going to win, you know I'm lying. There is no such thing in this world as 100% of anything except death and taxes. That's it. Nothing else is 100%. If I say to you, 99% certain we're going to win the case, and we lose it, and I say, doggone it, it was that 1% that I told you about. Remember? And then the client stabs you to death with a rusted knife. Or else I say 30% that we win. He said, oh, that little? I said, well, I'm afraid that's it. Well, maybe I shouldn't do it. I said, it's up to you. You know, if you think that you're going to go do it, do it. Now, there are some cases which are not contingency cases, when people come in and you say, I want to sue that person for $10 million of damages. And you listen to the facts of the case and you say, nope, this one is not a winnable case. Say, well, I want to do it anyway. I said, okay, bring me a retainer of $50,000 in cash, and we'll file a lawsuit. And when the $50,000 is run out, I stop, or else you give me whatever more money I want. Well, that's not fair. I said, why? You want me to be the risk taker of your lousy case? Why don't you take the risk of your own lousy case? And then you storm out of the office and go down the steps to the basement lawyer. Sorry, this is a nice basement. I'm not besmirching basements, you know. It's okay. All right, so those were things in general about how damages fit into a lawsuit. Now, I'm going to tell you things about some things in specific which are important. But before I do, let me give you something to take home. This is something to take home. You are not going to remember the definitions I'm going to give you here for the certain things. By the time you get to the streetcar, you're not going to remember it. So that's not the point. What I want you to get out of this hour and a half today is the flavor of how does a lawsuit get into the position of damages, and what are the pieces that have to fit together in order to get damages. And you having some knowledge of, there are other jurisdictions, not just the Hungarian ones. How does another jurisdiction do this? Now, I know absolute certainty that if at the corner of Nagykörút and Rákóczi út somebody ran a red light, drunk, hit you, what we call a T-bone, and crushed your leg, you would never in a million years get $2.5 million. I absolutely get, I'll take poison on that, okay? So you can go away with the knowledge that, gee, because what I'm telling you here is the truth. Those are verdicts that are possible. Now, there was a case in San Francisco. San Francisco has cable cars. Now, these are not villamushes. They are not run on electricity. They are pulled by a cable running underground, and the cable car has a clamp which goes through the slot, and when the car wants to be pulled, it squeezes onto the cable, and the cable pulls it, and when they want to let go, they open it up, and the car stops. And down the hill, you have brakes. Well, in the 80s, maybe the 70s, I'm at a point where I can say that with impunity. I started practicing in 1970, so a lot of water went under the bridge in the Danube. So there was a brake failure on the cable car that was naturally going downhill. If it was going uphill, wouldn't worry about a brake. But it was going downhill. And it couldn't stop the car, and eventually it crashed into an automobile, and several of the passengers were injured. Well, deep pocket defendant, the city owns the cable car, you sue the city. One of the passengers was a relatively attractive 28-year-old woman. Now, she wasn't visibly injured. In other words, no broken arms, broken back, broken leg, nothing. But she sued the city saying that she suffered psychological damages. What kind of psychological damages? She said, well, since the, I swear, this is true. I'm not making this up. Honestly, I'm not. Since the accident, I became a nymphomaniac. I tell you, I'll bring in the case. A lot of people laughed. The jury didn't. She had a very good lawyer, and the jury awarded her $25,000 above and beyond all her psychological examinations and treatments and seeing psychiatrists. $25,000 general damages for her becoming a nymphomaniac. So, when I say, 99 out of 100, right? That was the one. That was the one that won. Now, if she came to me, I said, lady, forget it. Go live on the beach and have your problem taken care of. I'm sure there's ways. I'm sure there's ways. So this is the situation where you have damages that I said unconscionable. I think every time the judge thought about these damages, he called a recess to go into his chambers and slap his knees and fall off the chair laughing. And he said, 25,000. I'm not going to touch it. That's just let this happy lady go home. So when do judges intervene? God knows. What's unconscionable? I don't know. You know, something that's unconscionable to you may not be unconscionable to me. Or if it's unconscionable to you, or shocks the mind. Yeah, I say, what's the matter with you? You know, you lived in a cave all your life. That's a perfectly normal thing. So it's so subjective. And the point I'm trying to make here is almost every case stands on its own feet. You can go look at precedents, and if the judge is willing, he'll say, you are right, sir. You're absolutely right. And if the judge is not willing, say, well, counsel, that's obviously this precedent doesn't apply. Subjective. Luck. You know? Ronald Reagan said it's better to be lucky than smart. Well, he knew what he was talking about. Okay. Now we are going to talk about a little bit on the different kinds of damages, because damages arising out of a contract are quite different than damages arising out of a tort. What happens if, say, I make a contract with you to buy my exotic Ferrari, 1965 Ferrari, for $100,000 next July the 1st. And I'll keep it in good shape until that day, and then you said, I need some time to get the money. I said, I'm not going to give you the car. Give me the money, I'll give you the car. Okay, fine. 1st of July comes. I say, I'm sorry, I don't have the money. Well, is there any question as to what my damages are? No. None of this business about $10 an hour for a leg. It's 100. There was a contract for 100,000. You didn't take the car. You owe me 100,000, and then I can give you the car or keep the car, whatever. We had a contract for 100,000. That's the damages. The benefit of my bargain is the 100,000. What happens if the market for exotic cars, especially Ferraris, goes through the roof between now and the 1st of July, and the car is now worth $200,000. Now, you're not going to be foolish enough not to go through the bargain, aren't you? You're going to say, here I am, here's 100, give me the car. And now I'm sitting there saying, how can I get out of this? I don't want to give a $200,000 car away for $100,000. So I breached the contract. So what's your damages? You say, well, it's not 100,000. I want the car, because I know the car is worth 200. So you say, Your Honor, damages are inadequate. I want an order-specific performance that Adam turn the car over to me in exchange for 100,000, which it's right here in cash. I'll give it over. Okay, so in a contract case, it's always a little difficulty as to what do you do? What do you do? You make a contract to buy or sell a house or whatever, and then one of the parties doesn't perform. You make a contract to have a house built. $50,000 to build a house. $10,000 you pay to the contractor when you make the agreement, and then periods of time, and then you will give another 10, another 20 until you wait until the house is finished. Then you pay him the remaining sum. And after 3 months and some work, he goes to Cuba because it's nice and warm there. And you say, wait a minute, I breach a contract. I want damages. Well, okay, what are your damages? Well, it's a little complex because you say, how much work had he done? What's the value of the work that's been done by him? Then you get a hold of 3 other contractors and say, how much will it take to complete the house the way he agreed to do it? And so you say, okay, one of them says 65,000, one says 75,000, one says 85,000. Well, the court is going to say, well, forget the 75 and the 85. We go with the lowest bidder. So you say, well, my damages are 65,000. And the question is, yeah, I get 65,000 from him. And what if this guy doesn't do as good a job? Because he had a very good reputation, and well, so he's got your 65,000, and you get a crappy house built. Then you say, who do I sue? I already sued him and got the money. Now I sued this guy because unworkmanlike work. That's another cause of action, because your contract assumes that work will be done in a workmanlike manner. But this is contract stuff. Contract damages will drive a lawyer crazy. Because, and I'll tell you why, you never, ever take a case on a contingency on a contract case. Because supposing we got the 65,000. Okay, I take it on a contingency of 33%. Okay, so I get 22,000, and you get the 43. And you say, I can't finish this house for 43 because he told me it's going to be 65. And you say, well, I'm not working for nothing. Nobody is happy. And if you come to me and say, I got this contract case because the guy took off for Cuba and he didn't build my house, I say, yeah, could you bring in a $20,000 retainer? Say, hey, if I had a $20,000, I'd hire another guy, etc., etc. Bad. Now, what happens in the tort case? In the tort case, you have various theories, the most common being negligence. Negligence is good enough of a case to create a cause of action on which you can win damages, including pain and suffering. What's pain and suffering? Well, pain and suffering is what happens when you lose a leg or an arm or an eye, or you have a broken hip, and the broken hip is mended or replaced, but you're going to probably be in some kind of medical facility for several weeks, if not months, during which time you're going to be in pain. And you have rights to be compensated for that. Pain and suffering. In contracts, forget it. No pain and suffering. What was the bargain? Well, the bargain was X. Well, here's X. And if you had to spend untold amount of hours looking for a new contractor and going out to the site and make sure he's doing it right, taking off from work for which you're not getting paid, you going to recover that? Not likely. Maybe the loss of wages, but not the other stuff. You are simply going to be out. So, of course, the other thing about torts is there are intentional torts, which entitle you to punitive damages, or exemplary damages, or penal damages, depending on what the court or the jurisdiction likes to call them. And what are they? Well, let's say that in Andras's case, it was pure negligence. No punitive damages in pure negligence. Well, when are there punitive damages? Well, punitive damages are when the defendant is bad, real bad, real bad. Malice, fraud, intentional hurt, where conduct is so bad, then you say, you can't do that. You can't do that without having to pay. So, on these cases, fraud, malice, and so forth, so on, you have punitive damages. Well, how much are they? Well, now there is where a good lawyer can be very imaginative. And why is that? Because one of the things that you can look at is the wealth of the defendant. Let's say that you have a company whose employees have really done you some terrible things. But it's a multinational company with multi-million dollars of annual income. So you look at the defendant's income. You say, Your Honor, we must punish this defendant in a way that it hurts. Now, when he's got $1 billion annual income, a paltry million or two, that's chump change. It's vest pocket money. We gotta hurt him so he won't do this again to somebody else. And of course, the law says yes. Well, there's something to it, except this unconscionable business. If it's so unconscionable, then you say, oh, you can't do that. For instance, in a situation where you have general damages of $75,000 for something that you were defrauded by a bank, but your actual damages are only $75,000, and you sued Raiffeisen, and you get their statements, they get their annual income, and you say to the judge, remember, Judge, we got to punish them. There's bad stuff. They're going to be out there doing it again. Doing it, everybody, they can do it. So we got to hit them. And so the jury says, okay, 15 million punitives, 75,000 actual. And the judge says, way out of proportion. If you've only been damaged 75,000, 15 million is just way out of proportion. Nobody can be that bad. I'll cut it to 1.5 million. And even that's too much. So they meddle. But punitives are something that if you have a case that it can be applied, that is a wonderful way to approach it. But you also have to remember not to get greedy. Because if you get greedy, the judge might take all of it away from you. And you know, you also, you have to remember, you know, you're a lawyer, you can't move from country to country every year. You're likely to go back to the same court, the same judge, and he's going to say, I remember this Adam guy. He's a pig. I gotta watch him like a hawk. At the same time, if your previous conduct is such that you make an impression that you're a decent, honest, straight-talking fellow, the judge is going to say, I like this guy. Let me see what he's got to say. And he's going to treat you through the case and your client with that mindset. Psychology. It's another little bit of psychology that you gotta use. Okay, so the tort and the contract issue. What I want to just finish on that score is that there's a phrase in the American common law of a case sounding in tort or sounding in contract. Supposing I have a contract with Andras, and he maliciously breaches the contract. I don't sue him on the contract breach. I sue him for a malicious act of breaching the contract. Why? Because I get punitive damages. And the judge looks at the complaint and says, Adam, this case is sounding in contract. I know you're trying to bring this malicious garbage in, but I wasn't born yesterday. I know what you're going after. This will be a contract lawsuit. And you sheepishly say, yes, Your Honor. And then you present your evidence as a breach of contract. Okay, now, in the tort case, another thing that we kind of chatted with Andras earlier is that there's a saying that you takes your plaintiff as you finds him, which means that you don't know whom you're going to hit. If this guy hits Andras's car, not knowing, of course, that he bleeds very easily. And before the ambulance gets there, he is bled to death. Now the family has a wrongful death action for a supporting father of 40, etc., etc., etc. And the defendant says, but it was just a car accident, for heaven's sakes. He said, yeah, but this particular fellow that you hit, that you didn't know had this problem, that you can't stop his bleeding, it's not his fault, it's yours. You take your plaintiff as you find him. So if you do harm, an eggshell, hit somebody on the head with an umbrella, okay? Normally you have a bump on the head. This particular fellow, his skull is crushed and he dies. You say, well, yeah, but all I did was hit him with an umbrella. You didn't know that he had a thin skull. It's your problem. So that's another very important element in tort. How do you get this? All right, now I want to talk a little bit about other types of damages. We talked about general damages, which fall in the category of pain and suffering and so forth. What happens in the case of a loss of profit? A loss of profit case, okay? Now, if you're working for a company 8 to 5 and you have a salary of a middle-level manager, that's clearly identifiable how much you're making a month. And by the time the case comes to trial, you will have missed 4 months of work. Well, it doesn't take an atomic physicist to figure out 4 months times your monthly salary, that's your loss of income. And then you have a doctor come on the stand and testify that, Judge, it seems that with this kind of injury, it's my medical opinion that this person will most likely miss work over the next 10 years of maybe a total of a year and a half. Okay? Future loss of income. Future loss of income. What's been done is done. It's easy to compute how much your income was and how much you lost from the date of the injury until the date of the trial. But and then of course the big key here is more likely than not. It's not enough to say, well, it's possible that he's going to lose a year and a half. No, the doctor and you say, Doc, how much is your fee so far? Oh, $2,000. So, well, let's make it 3, and you go in there and you tell him that your medical opinion, it's going to be at least a year and a half, 2 years that I'm going to lose from my job in the future. Because once the case is over, Nobody's going to come back and say, well, let's see how much work this guy lost 10 years from now. We'll look back on the record. Maybe he's not going to lose any. But the court says this is the time to decide everything. So we're going to look at loss of income. But what about profit? What if you're a businessman and subject to recessions, subject to the fluctuations of the market, subject to the weather? Supposing you're selling something that in good weather sells well, and if it's a terrible summer, you experience a 50% loss. And you have to look into the future and say, what about future loss of profits? A terribly complicated thing. And again, inventive thinking is the key. You sit there and you say, how do I present this case as to make an impression? And you can have a jury that's so lost in these numbers that they're never going to understand it. And the law says, yes, you can have loss of profits, but they cannot be speculative. You have to have some rational basis on which to compute this. So what do? You get somebody from the Economics University of Budapest, and he's got his charts and lays it out that this kind of a business or profession is going to do so much. And historically, in the last 5 years, they've done this. The fluctuations were such, the average is that, you do a good job. But you say to yourself in the beginning, do I want a jury to hear this? Or are they going to get lost? After the first row of numbers, they're going to say, oh, God, how long is this going to go on? When is lunchtime? So you say, well, Your Honor, we'll waive jury. And if the other side is smart, they say, oh, no, we do not waive jury. But if they're stupid, they waive jury. And so now you have a judge who's experienced, and you lay this out, and you put your client on, and he'll testify that in his experience, in this business, etc., a good client will win your case. A bad client will lose you one. I had an Egyptian jeweler, and he came to my office, and he was a client, a long-standing, and he told me that this newspaper screwed up his ads. He had several stores, Christmas time, and he advertised 15 pieces of merchandise for this store, 25 pieces of merchandise for that store, very big distance between them, and the newspaper screwed it up. The 25 was for this, and the 15 was there, and the customers come flooding in. None of the merchandise was there because it was at the other store hundreds of miles away. And so he said, breach of contract, you screwed up the ad, I paid you for the ad. And legally, and the funny thing was, at the end of the case, the judge says to me, you win. But the damages are too speculative. So all you get is your cost of filing a lawsuit, and peanuts, nothing. We were seeking $200,000 loss of profits. Didn't get a single dime. Why? Because the plaintiff took the stand, and now, Mr. Jawad, what, in your opinion, were your losses? I don't know. Mr. Jawad, that's not what you told me in my office. I can't say that, of course. But that's what happened. And the judge said, I did not get sufficient information on which to put a number on the loss of profits. I know that there were loss of profits, but I can't pull a figure out of my hat. It just doesn't work. Okay. Now, we're moving right along here. The compensatory damages, which are compensatory in tort, contract, everything, on the outline, which, did they get an outline? No, that's okay. It doesn't matter. Generally, the law says that they have to be direct, immediate, and proximate. Now, again, I'm not going to walk out to the streetcar and say, excuse me, could you tell me what were those three things? He said, oh, God, I forgot. But you don't have to remember. But there are certain elements, direct, immediate, and proximate. Now, direct, it's obvious if you take the situation of a car accident. It's the plainest, clearest thing. Two cars collide, it's direct. Immediate, it all happens right there. His loss of the leg is not only the result of this thing, but it's proximately caused. Now, that word has sent a lot of lawyers into insane asylums, because many times the judge would say, well, counsel, the proximate causation, I just don't feel is there. I'll give you an example just to tickle your fancy. Let's say that a train is coming down the railroad tracks. Crossing the railroad tracks is a lorry or a big truck carrying fuel oil. He broke down. He cannot move. The train hits him, and there's a big explosion. Anybody injured in the train obviously is directly, immediately, and proximately injured, right? You agree? Everybody agrees, right? If there's anybody left in the truck other than even the driver, whatever, if it's not his fault, he would be potentially a plaintiff. If anybody left alive, they would be directly, immediately, and proximately injured. If there were some children playing within 100 meters of it and they were injured, clear. Now, the lorry or the truck explodes. 2 kilometers away, there is a horse grazing. The horse is frightened by the explosion, and he starts running down across the field. He runs into a village, and he tramples on a child that's playing in the street. Okay, you got the picture? That's not, the child has no cause of action against either the owner of the oil truck or the driver of the train or anybody. Why? Because it is not proximately caused. Yeah, you say, but wait a minute. If the train didn't hit the truck, and if the truck didn't explode it, and if the horse didn't get scared because of it, and it didn't gallop down the street and didn't drown, actual causation is not an issue. The question is, was it proximate? What does it mean? In the normal situation of human events, could you possibly imagine a situation so arcane and crazy that a horse would get scared 2 kilometers away and start galloping and run over a kid another 3 kilometers away? It is not sufficiently connected. It's not sufficiently close. It's not foreseeable. What's foreseeable? Well, in a normal, ordinary course of human events, can you connect the dots from A, the explosion, B, the injury to the child? And the law says no. Now, I could play with you and say, well, let's back it up. Let's say that the horse was only 50 meters from the explosion and the child was only another 25 meters away. You say, well, it's a little stronger. Is it strong enough? Well, we could try it with the judge. So it's all very subjective. All of these things, you cannot say, even with all the hundreds of thousands of precedent that American law is replete with, you cannot say, this is ironclad law. No. It's subjective, and it stays subjective. So, let me see if there's anything left that's really worth spending some time on. The answer is no. I think I have stayed within my time limit, but if you have any questions, I would be delighted to answer them. And if you want to know where the bathroom is, it's right there. Other than that, Andras, that's it? Okay. Anybody want a pogacha? So, no questions? All right. Okay.